Our first speaker to my right is trial lawyer Joe Krasovec from Schiff Hardin in Chicago. Schiff Hardin, of course, is who we have to thank for the surroundings that we're here for. A lot of us have come from far away. I think Joe commuted all of about 2 floors this morning to make it here. He tries commercial and product liability cases. He also advises on advises clients in addition to trying cases on product labeling instructions, testing, and design. This morning, based on his experience with clients who are sued in the United States, where their products are distributed and used, Joe's going to discuss issues that are encountered when defending product and service providers. So please welcome Joe Krasovec.
Well, good morning, everybody. It's my pleasure to present to you, and I'm delighted that you've all come here. I think it'll be a great program, and it'll be a wonderful day. My presentation this morning is going to center on situations in which you're defending, you have U.S. litigation, and you receive discovery requests where you're being asked to produce materials that have to do with products or services or activities that are going on overseas. It's not even cliche anymore to say that we live in a global economy. Countries that are 1/10 of the size and population of ours now seem to be affecting our stock market on a daily basis. And so your opponents in U.S. litigation are immediately going to start mining for information about what your companies, your affiliates, your subsidiaries are doing overseas. And they're going to try to use that information to compare what's going on overseas with what the issues are in the U.S. litigation. Now, my practice centers primarily on product liability work, but these principles can be applied to any kind of litigation, any kind of business litigation, again, where your client, your company, has some kind of overseas involvement. How do you keep the case focused on what's going on in the U.S., what your client's business activities are here, versus what they're doing overseas? Now, the first thing your opponent's oftentimes going to do, they're going to go on your client's website, and they're going to look for what it is that your client is doing overseas. This is a client that I do work for, Graco. They're a children's products manufacturer. This is one of their websites. This is their European website. And you can see it says, it is this unbeatable combination of quality, innovation, and value for money that has allowed Graco to grow into the #1 wheeled goods manufacturer, that's strollers, and the #2 car seat manufacturer in the UK. That's there for everybody to see. That's there for your opponents to see, or Graco's opponents to see. And so on the heels of your opponent, or Graco's opponent in this instance, looking at that, you get a discovery request. Name every country where you sell your car seats outside of the United States, and include with your answer the standards applicable to those products, the alternative designs and models of infant restraints those products included, not included and or sold in the U.S., and identify the foreign safety regulations applicable to those products manufactured outside the United States. The strategy here on the part of the plaintiffs in this case is to look at what the product features are that are being offered in the UK and try to show that, A, those are alternative designs. Obviously, they're reasonably feasible because they're actually being sold somewhere. They're economically feasible because somebody's buying them. They're the #2 seller in the UK. And they can be used here then to show that had those design features, had those practices been employed in the US product, that would have either prevented the accident altogether or would have eliminated or minimized the injuries involved in the case. And as I said, again, a lot of what I'm going to talk about is product liability oriented, but it's the same concepts that can apply in business litigation. What practices are your client's affiliates overseas employing that, had they been employed, policies or practices, had they been employed in the United States, would have prevented or precluded the damages or the issues involved? And believe me, I've seen it in a number of cases. They're going to be relentless, like the TSA is, in terms of looking for the water bottle that you left in your carry-on when you tried to go through. They're going to come at you with all kinds of discovery requests. So how do we deal with this? There's a three-part strategy, and the first part of the first aspect of the strategy is to use the discovery rules at your disposal to preclude or limit the materials that you have to produce as beyond the scope of permissible discovery in the United States. If the material has to be produced, if you're ordered to produce it then after that fight, you preclude the use of that information at trial, argue its inadmissibility, or you minimize its impact if it in fact is admitted. So let's look at each one of those. The question with respect to the discoverability of the records is, are they within your possession, custody, or control? Now, if they're within the U.S. entity's possession or custody, you're going to have to produce it. The central issue becomes whether your client, whether the U.S. entity has control over the materials that exist overseas. And control is defined in the federal rules and for the most part in most state rules as the legal right to obtain the documents requested upon demand. Now typically, and this is classic Rule 34 discoverability law, typically you see three situations in which there's a U.S. entity with a foreign, has a relationship to a foreign entity. There are typically three types of situations that you run into. One is where the U.S. entity is a parent of a foreign subsidiary. Another is where the U.S. entity is a subsidiary of a foreign parent. And the third is where there's just some business affiliation between them. So let's look at each one of those. Your opponent's going to want to say that it's just a small world out there. Just like the ride at Disney World. It's all one big happy family. And asking for materials that an affiliate might possess in France is just like asking for something that exists up in Wisconsin. You have to show that it's not a small world after all. The Earth's surface area is 148 million square miles. And going all the way overseas to get a bunch of stuff is going to be real hard and very burdensome. So let's look at the U.S. parent foreign subsidiary situation. So the company being sued in the United States is a parent corporation and it has a foreign subsidiary. Case law says that if the subsidiary acts as a direct instrumentality of and in direct cooperation with its parent, and where the properties and affairs of the two were inextricably confused as to a particular transaction, they're going to require the U.S. parent to go get the information and produce it in the U.S. litigation. Now, what does all that as a practical matter mean? It means that if the subsidiary does not have independent management, if it doesn't have independent capital, if it doesn't have an independent business function, and you can't show that, then in all likelihood, your opponent will be able to show that the parent controls the subsidiary sufficiently to get the information. So you've got to make the argument that the foreign company has its own management structure, conducts its own business affairs, has its own bank accounts, and conducts a separate business from the U.S. parent. Now let's look at the other way around. You have a U.S. subsidiary and a foreign parent. The discovery request is served on the U.S. subsidiary, and the material belongs to the foreign parent. Here it's the alter ego doctrine. In essence, is the subsidiary here acting as the agent of the parent with respect to the transaction at issue? If the subsidiary secures documents as an ordinary practice in the ordinary course from its parent to do its business, and ultimately if the subsidiary markets the parent's products in the United States, then that will establish sufficient control that the U.S. subsidiary can demand the foreign parent to produce documentation. The last situation is an affiliate business relationship, a joint venture, some kind of business relationship. And the question there is there a contractual right on the part of the U.S. entity to demand the information that the foreign entity has? Or is there an ongoing business practice with respect to the relationship between the two that, again, on a regular basis, the U.S. entity gets information from the parent? If your opponent can establish those things, then the court will require you to produce the information. So again, you want to look at the contractual relationship and see if there's anything in there that allows the U.S. entity to demand the documentation. If there's not, you've got a pretty good shot at keeping that information from being discoverable. Also, and I'm going to get to probably the most important point of my presentation, you can also argue that the overseas records simply aren't reasonably calculated to lead to relevant evidence or admissible evidence. You begin to educate the court to tie the materials that are being sought overseas with respect to compliance with some type of foreign standard, custom, or regulation. And again, this is really the key point of the presentation. Ultimately, what you're going to try to argue is that even if the material is produced, the reason that something is done overseas is because there's a particular practice there, or regulation, or standard, or law that requires it to be done that way over there. And you want to start building the arguments that lay the foundation that you can make that argument to the court, because that's going to help you not only with respect to discoverability, but admissibility as well. You also need to lay the groundwork to argue that whatever's done overseas does not demonstrate knowledge of a hazard or issue in the U.S. Last thing on discoverability, you want to make sure that you still argue burdensomeness. In other words, it is a big world, and it is hard to go get materials from a lot of different places. It's not easy, and so a lot of times you can whittle down the scope of the discovery request. Say there's 14 different affiliates, you force the plaintiffs to pick 3 or 4. There's case law where the opponents have been required to whittle down the scope of their discovery requests. Now, I concede that it's hard to win the discovery battle, particularly if you've got businesses that are pretty intertwined with each other in terms of their operations. So now the question becomes, how do you keep this information out? And your best argument, the shield that you have or your weapon, are Rules 402 and 403. I always tell people never forget Rule 403. And Rule 403, Federal Rule of Evidence 403, again, just as a reminder, says, if the probative value of the evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence, then that evidence will stay out. And this is where you start to explain to the court that the reason something's done overseas is because that's the way they do it there. We shake hands here overseas. Some cultures you bow. We don't wear Speedos here for obvious reasons. That's Giorgio Armani, by the way, and so if he can't carry that off in the United States, I don't know who can. We don't drink warm beer in the United States. And we don't have our children ride around in buckets. Instead, we use infant child restraints. What you need to do is begin to educate the court that the reason that a practice is done overseas the way it's done, or a product is sold there, or there are design features in the United States, is because there's a foreign standard or requirement that the product or practice is done that way. You tie the product design or practice to a foreign standard as the reason for deviation from the U.S. counterpart. Now, how do you do that? There's really 2 central ways to do it. One is with your witnesses. And my recommendation is that if you're going to get into this battle, you start to build your foundation with your witnesses very early on. You can use a company witness or an expert to establish that the product made to the foreign standard would not comply with U.S. regulations or standards, or that based on the application of the U.S. regulation or standard, the foreign version could not be sold in the United States. So you need to have either an expert witness or a company witness that can explain the differences between the 2 countries, the laws, the regulations, or just the custom and practices as to why something's done in the United States or overseas versus how it's done in the United States. That gives you the ability then to argue to the court that if we get into admitting all of this information from overseas, we're going to have to explain to the jury why it is that we don't wear Speedos here, why it is we don't drink warm beer, and that's going to be a huge sideshow that the court is not going to want to get involved in. And I've been very successful in convincing courts that we don't want to go there because it's going to add days to the trial, and all it's going to do is confuse the jury. The other way to do this is through testing. you actually show through your testing that the products sold overseas would not comply with U.S. standards, or that the foreign features or designs would not be acceptable to U.S. consumers, or show that the inclusion of the foreign design or feature would not have made any difference in the issues in the lawsuit that you're defending. So either through witnesses or testing, you have to start early on to lay the foundation to be able to argue that if we get into that, into the overseas stuff, we're just going to be off on a big sideshow. We're just going to confuse the jury, we're going to mislead them, and we're going to add days to the trial. And most judges don't want to go there, and they're worried that that would be reversible error. So that's how you keep it out. So what are our takeaways? First of all, with regard to discovery, you try to just keep it from being produced altogether. And that centers around the lack of control over the information. So you got to look at what are the relationships between the U.S. entity and the overseas entity, and basically can the U.S. entity demand that the overseas entity provide the information to the U.S. entity to produce. If you have to produce it, you establish that the foreign service or product is different because of some foreign law, regulation, standard, or requirement. And you do that through your witnesses and through testing. And then ultimately, if it does get produced, you show at trial to the jury that the foreign service or product could not be offered in the U.S. because it would violate a U.S. law, regulation, standard, or custom. In other words, you can't sell the product here because it would violate a federal government regulation. So those are the 3 steps to deal with discovery requests, which I think we all get with regard to stuff that's going on overseas. Preclude its discoverability if you can't. Preclude its admissibility, and if you can't, show why it's irrelevant to the jury. Thank you very much. I hope you enjoyed this, and I hope you enjoy the rest of your day.